Last name?
Here today in front of the courthouse where there's a hearing on the use of Skelly in the case of Margaret Reyes, who is a UESF teacher and who was disciplined for refusing to go into the PAR program, Peer Assisted Review. So welcome.
Thank you so much for being here. It's July 29th and we're here to speak to the judge, Ethan Schulman. Hopefully he will see my side of the story, that those were not Skelly hearings last year in 2018. United Educators of San Francisco said they weren't Skelly hearings. Their legal counsel said they weren't Skelly hearings. But the school district, despite having lawyers in-house, several of them, hired a law firm by the name of Bertrand, Fox, Elliott, Osmond, and Wenzel, I believe. And so they hired an outside law firm to basically, buy a win, it looks like, and rewrite the narrative that those were Skelly hearings. They were not Skelly hearings. The notices weren't Skelly compliant. In one of the cases, none of them were Skelly hearings proper. On the March 23rd, 2018, I was told I was going to a meeting with Richard Kirchie. It turned out to be a Skelly hearing when I got there. They're now saying I had 11 days notice. I did not. I didn't even have 11 minutes notice. And they're saying that Ana de Arce, the hearing officer, is sufficiently removed from PAR. That is absolutely not true. Ana de Arce was on the PAR panel at the time she did my hearing. And Ana de Arce was a PAR coach. She was the lead PAR coach for years. She went straight from PAR coach to principal. So she's not sufficiently removed to do the hearing. So that's also Anikia Ford-Morthel is not sufficiently removed to do the hearing, nor was the third one that's not before the court today. A man by the name of David George is not sufficiently removed to do the hearing. Also, they said that I was insubordinate. I was not insubordinate. The superintendent broke the ed code in referring me to PAR. My union did not refer me for PAR. Greg John in HR wrote a letter to the superintendent, and the superintendent overrode my union and put me in PAR, which was illegal. And he used an Appendix F clause, Appendix F in the contract, which it's illegal. An appendix, you can't change the contract. And it's Appendix F is buried in the contract, and it contradicts much of the contract. And also it's against the ed code. So the superintendent is not supposed to be able to override the union, but he did. Thank you so much.
Can you just say what PAR is?
PAR is something called peer assistance and review. There is significant evidence that it is targeting, in some places, African American teachers. The sample set here in San Francisco is a little too small for the African American teachers, but without a doubt, it's targeting older teachers, particularly over the age of 45. The Z-score, if you will, which shows one group that there's a disparate impact on one group. The Z-score is over 7, and according to the Hazelwood case, to prove that something is having a disparate impact on one protected class, you only need a Z-score of 2 to 3. So it's more than double what it needs to be to prove that this program is having a disparate impact on older teachers. Personally, I believe it's a way to keep pensions down. It's a pension liability. It reduces pensions. It gets people to resign before they normally would and gets the pensions down. So I believe they're using it as a pension liability or reduction. It's also a way to really scare people, right? Because once you get in PAR, you have to sign non-disclosure agreements, etc., and you can't file grievances. You can't even hear what the panel says about you. So, yeah. Anything else?
The role of the union, UESF?
Yeah, well, so in my case, they definitely said these were not Skelly hearings. They put it in writing, they registered their objection, and they did register their objection to the particular hearing officer. That said, they're not here today. Where are they? I've been asking them for help for months and months. The union is aware of a lot. They're aware of the disparate impact on one group. They actually participate in PAR. They're aware it hurts people. They are aware that the contract was broken and the law was broken. They're also aware that Mike Quinn in San Francisco Legal Department several months ago got a hold of some medical records that he had held on to for 6+ years against a federal court judge's orders, and sent me those medical records. And in the timing with this case, I believe it was an attempt to extort me and scare me. They've also published my full driver's license online in full display. They've published my full birth date.
So the we're here to fight against very unfair practice with something that was supposedly supposed to help teachers and is just being used against teachers unfairly, used by bosses. And this is something that is, this is only really one example. In many ways, the school district unfairly targets teachers, pushes them out, gets rid of them when they don't deserve that. Could be something about them, like they're, like we talked about older teachers. Maybe they're making too much money, they want to get rid of them, and they want to avoid giving out their pensions. Other teachers from other groups that they don't think are desirable. Teachers of color, also teachers with disabilities are targeted. And any teacher who speaks up and is, a dissident in any way and is active in the union in a way that the bosses don't like, they can be targeted as well. And I used to work for the school district, and I was also pushed out unfairly, not through PAR, but through other means. And, it was the same old story where they couldn't even tell me why. And they didn't even bother helping me. There was something.
There's a program called PAR, Peer Assisted Review, which is supposed to help teachers, but has been used to fire senior teachers, African American, Latino teachers. And we believe that the district is discriminatory in how they use this program. They're bringing in younger teachers, getting rid of senior teachers, and saving money. So we need to support Margaret Reyes. We need to end this harassment, this bullying of teachers, and stand up for working people in San Francisco. They spend over $1 million a year from a parcel tax for this PAR program. And one of the reasons she did not want to go in the PAR program is that one of the coaches in the PAR program was her principal who had been bullying her. So what kind of program is it that you have to face a bully and you're going to be you're harassed and bullied in this PAR program, which is supposed to help teachers? This is not just the case in San Francisco, it's also the case in Oakland, Berkeley Unified School District, and also Los Angeles Unified School District. The school districts around the state have an incentive to get rid of senior teachers because they can cut their costs, cut their pensions, and basically save money. And that's really why, one of the reasons there's a teacher shortage in the United States, because senior teachers are being harassed and bullied out of their jobs, even couple of years prior to the retirements. So today, Margaret Reyes' case is going on here at this courthouse, and the San Francisco Unified School District is spending thousands and thousands of dollars trying to fire her improperly. She didn't have a proper Skelly hearing, and this has happened to other teachers. They ignore the law and have a rigged hearing where she doesn't have the right to really cross-examine. They bring in evidence which is not able to be challenged because of the procedure, and it's unfair and undemocratic. So what we're saying here today is hands off Margaret Reyes. Margaret Reyes has to be, she should win her case. The judge should not allow the district to illegally fire her. And this raises the question of systemic discrimination against senior teachers, systemic discrimination against African American and Latino teachers. And this has been proven in the documentation, the statistics of teachers in Los Angeles, Berkeley, and in San Francisco. So why is the district spending tens of thousands of dollars to get rid of Margaret Reyes, who had very good ratings, was a good teacher?
Put things under seal as well.
And to put things under seal, to keep it a secret. They also demand non-disclosure agreements when teachers leave. And this is a public agency. So we're saying that there's serious systemic discrimination that has to be addressed. Margaret Reyes, hands off Margaret Reyes, stop the harassment, stop the bullying, and bring Margaret back to the class. I mean, this is a shortage of good teachers in San Francisco, and yet they're spending tens of thousands of dollars to get rid of a teacher who is doing her job. What kind of system is it when the school district doesn't have money for maintenance, doesn't have money for more salaries for teachers and staff?
On the particular law firms that they have used to defend their PAR program, I know for sure they've used one called Jackson Lewis several times. You can look up Jackson Lewis and Bertrand Fox, Elliott, Osmond, and Wenzel.
So we're here to defend Margaret Reyes. She's a teacher who has been retaliated against for refusing to go through the PAR program, peer assisted review. It's a program which is supposed to help teachers. That was why it was set up, but it's been used to target senior teachers, African American and Latino teachers. And we're saying this program should be shut down. They're spending over $1 million a year on this program, and it's been used to target teachers, dissidents in the union, and we think it is a very reactionary program. So that's why we're here today. We're calling on the judge to defend Margaret Reyes' right to a hearing and defend against the fake Skelly hearing that the district had. Why would the San Francisco Unified School District, Vincent Matthews, spend tens of thousands of dollars for lawyers to destroy the lifetime career of Margaret Reyes as a teacher? This is one of the things we have to ask.
I don't have a whole lot to say.
Okay.
So the we're here to fight against very unfair practice with something that was supposedly supposed to help teachers and is just being used against teachers unfairly, used by bosses. And this is something that is, this is only really one example. In many ways, the school district unfairly targets teachers, pushes them out, gets rid of them when they don't deserve that. Could be something about them, like they're, like we talked about older teachers. Maybe they're making too much money, they want to get rid of them, and they want to avoid giving out their pensions. Other teachers from other groups that they don't think are desirable. Teachers of color, also teachers with disabilities are targeted, and any teacher who speaks up and is a dissident in any way and is active in the union in a way that the bosses don't like, they can be targeted as well. And I used to work for the school district, and I was also pushed out unfairly, not through PAR, but through other means. And it was the same old story where they couldn't even tell me why, and they didn't even bother helping me. There was something they didn't like. They should have, helped me to do something. But clearly, they had no interest in that. They just wanted to get rid of me. So that's why I'm here today.
Thank you. Okay, we're here today to defend Margaret Reyes, who has a trial today. And the trial is that they did not have a proper Skelly hearing. They're using this PAR program to get rid of senior teachers, and we're saying that has to stop.
What we're about to go in for is not about my being dismissed. That's in a different case. What we're about to go in for is the two fake Skelly hearings last year in 2018, in March and April of 2018. The union has been invited, they're not here. Also, they have hired a law firm, like I said before, just to defend fake Skelly hearings. This is not a termination. I was terminated, but that's not what this is about. This is about their fake Skelly hearings. They hired a law firm that I would assume is very expensive. Mike Quinn is in there. He is the district's counsel. I don't know why the district can't just send him. Also, just a side note, it's my understanding that the district has hired somebody that used to work at Bertrand, Fox and Elliott, a woman who went up against a man who worked at a high school who contested par a few years ago. She was working at Bertrand, Fox and Elliott at the time, and then the school district brought her over from there. So I'm about to go in up against 3 attorneys. All I want is a fair hearing. I was not given Skelly hearings. The union said they weren't Skelly hearings. The union's legal counsel said they weren't Skelly hearings. Skelly hearings in general, are enshrined in the Constitution. It's a serious subject. I'm mostly saddened that they might be able to buy a win. They did not buy justice. I want to be very clear about that. They did not buy justice. If they win, they bought a win on this. Those were not Skelly hearings. So thank you for being here.
Where is UESF? I mean, they should be representing you here about the Skelly hearings. You wanted to talk
Absolutely, I've asked. They're not here. They have said those weren't Skelly hearings. I've presented evidence to the court that both UESF and their legal counsel said those weren't Skelly hearings, but they're not here today. They haven't been with me in any of this. I've been all by myself. So it's been
And where
hard.
does that leave teachers who don't have representation? It's very difficult to deal with that.
Sure. Right. I can only tell my own experience. It's hard. It's really, really hard. Somebody said to me, "Thank you for putting a bell on the UESF cat," and I said, "Wow, I'm really." That is what I'm trying to do. I'm trying to bell the cat. Unfortunately, the cat does need more than a bell. The cat needs a body cam, and the cat needs to be scrutinized by an outside agency, and the people pointing out and blowing the whistle do need fair representation. We can't do it alone. They can hire people to outmaneuver us.
And how many teachers have been affected by PAR?
They're very tight on the data. One of the reasons they're going after me so hard is because I was the one who got the data in 2017. It was an accident. They accidentally sent it to me. They sent it to the then union president, Lita Blanc, and Lita Blanc sent it to me, and I then sent it around and did an analysis on it.
And what did it show?
Oh, it showed with a Z-score of over 7 that it is targeting teachers over the age of 45. There is no doubt it is impossible to dispute that it is having a disparate impact on teachers over 45.
And this is discriminatory. It's illegal. Why hasn't the union filed suit for discrimination against a category of senior teachers?
I don't know. I've asked them to, and in both of those what I was told were meetings that turned into fake Skelly hearings, I gave them evidence of it, that it was discriminatory. I've given the court evidence. I don't know why they're not doing anything. I believe it's because PAR is keeps pensions down. There's kind of a real hockey stick of how much your pension goes up after a certain age, and if they can get people to go out before that age, it's called a hockey stick in finance because it kind of goes like this and then it goes straight up. So if they can get you to go out before that age, before your pension really goes out on a large scale all over the state, that's a huge pension saving. Also, I believe, and I know I'm not alone in this belief, that the union uses it to quell dissent within the union. The Solomon slate runs pretty much completely unopposed, and we need to start looking into what part that PAR played in Solomon's people that opposed her even being able to run for office within the union. We need to look into that because I believe it's significant.
And this non-disclosure agreements, what is that all about?
Yeah, I never signed one. So
What was it? What did they ask you to sign? What did they want you to sign?
Before they wanted me to start PAR, I was going to sign stuff that it's all confidential and that I don't have grievance rights and other things. And I had heard from enough people over the years that the PAR panel, you don't even get to hear what they're talking about with you, that I've heard, I don't know if it's true, that the PAR panel has your principal come in and you don't get to be there to rebut what your principal says. You have to leave, and then you don't get to hear any of the decision-making process. A lot of people believe they're breaking the Brown Act in the PAR panel. I don't know where that is, and that's not before the court today.
And how is it that PAR is embedded in the parcel tax
Yeah, so that's an interesting one. In 2008, we had a Proposition A parcel tax, and we thought, yay, 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 this is more money for teachers, yay, vote for it. And yeah, a little bit of more money went to teachers, but they used $1 million a year, the last I heard it was just under $1 million a year of the Prop A parcel tax to fund their PAR program and to grow their PAR program. So also within Prop A, part of the agreement was that the superintendent would be able to override the union if the union doesn't want to put someone in PAR. And that is in direct contrast to 44502B in the California Ed Code. So also it contradicts our own CBA, our own contract. So
Has the union filed a grievance around that?
no, the union agreed to put this Appendix F into the contract, but it's buried under the body of the contract. So body of the contract says that that the union and the school district must agree before a person starts PAR. Then underneath that, hidden, is an Appendix F. Now here's the thing, I'm pretty sure it's illegal to have that appendix. It was hidden. You can't have the voters voting on your contract. Also, in legal terms, it should be an addendum, not an appendix. So I believe it's completely illegal. And my union did not recommend me for PAR. Greg John, the then PAR panelist who had been my principal harassing me for years, along with Mike Quinn and a few others, wrote a letter to Vincent Matthews saying her union doesn't want her in PAR, but we want her, and Vincent Matthews signed it and forced me into PAR against my union. And that does go against the Ed Code, and it goes against their own contract. And yeah, so that's where we're at.
And the Board of Education, Mark Sanchez, where are they in this? Do they vote to terminate you because you refuse to go through PAR?
So the answer is I don't know, because they did it in private. Back in September, I had about a day's notice that they were going to do it. I sent them all an email saying I want it in public. I don't
This
want
is
it.
the San Francisco Unified School District Board of Education.
Correct.
Yeah.
There's some of the people that are on there are different. So this wasn't some of the people that are there now. There's about 3 of them that did this. Or I don't know if they did it, because I sent them that I wanted it to be done in public. They did it in private. And then the hearing was done in private. I didn't get to hear what was done. The paperwork I got later did not have the superintendent's signature on it. It said Secretary of Board of Education, which would be the superintendent, and they tried to say it was the superintendent's signature, but then they later said it was a man by the name of Judson Steele's signature. I called Judson Steele. He wouldn't talk to me. He said that he's been told by HR to not talk about it. So there we are, right? There's I don't know I don't know how the board voted. How could I know, right? So it's a problem. But I know that the superintendent did not sign the paperwork. Also, the man who delivered it to me, John Richard Reclasato, impersonated a delivery officer, and I can't make this up. He actually signed under penalty of perjury that he worked for a group called First Legal, and he was a doc server. And it turned out he doesn't work for them, and he works for the school district, but he signed under penalty that he works for this company in Santa Monica, and he gave me these documents, and they did not match the documents that my union was emailed. The district never emailed me any documents. They send them to the union, and the union says they forwarded me the true and correct documents. I don't know.
Thousands and thousands of dollars to fire Margaret Reyes.
It's not to fire, it's to defend their right to do fake Skelly here. This isn't even the fire one.
Here they are.
It should be. Good.
I'll catch you down there. Just hold on your. Thank you. So I'm very disappointed in Judge Ethan Schulman's ruling. This was supposed to be about whether or not I got Skelly hearings. He let it turn into something about par, and I think I did display that I had adequate reason to not engage in par. And he cut me off several times, but I did the best I could. I'm disappointed in his ruling. They had a team of lawyers, so I say they bought a win. They did not buy justice. And I hope that this all sheds some light on it all. I hope it sheds some light on the abuse of power that a few people at SFUSD are engaged in. Not SFUSD. Most people at SFUSD are lovely. The thousands of people that work hard and the students are amazing. But there's a few, and I hope that this sheds some light on it.